And Pete, you're live.
Okay, welcome everyone, and thank you for joining us today. I'm Pete Prummer, a patent attorney and partner in the intellectual property practice of the law firm Nixon Peabody, who has been gracious to provide us the WebEx platform for today's event. I, along with Mickey Piat of the Chicago-Kent Law School, are the co-chairs of the Program and Events Committee of the Illinois Intellectual Property Alliance, your host for today's Creators Roundtable. We're excited to have you join us for what is a milestone inaugural event for our young organization. The Illinois Intellectual Property Alliance was formed earlier this year as an organization for professionals throughout the Illinois business ecosystem, including creators, protectors, and enablers of IP. Our members come from a wide range of fields that touch on IP, such as private companies, academia, business advisory services, community organizations, incubators and accelerators, law firms, and research laboratories. The Alliance also engages with state and federal government. For example, our next event on November 10th will include Damian Porcari, the Midwest Regional Director of the U.S. Patent and Trademark Office. Please check your inboxes in our website regularly for more details for our upcoming programming. Our theme for today's program is IP supports innovation, but does it support innovators? We have a fantastic group of speakers, all three of whom are both inventors and entrepreneurs in their own right. They will share with us their experiences with and perceptions of the IP protections available to innovators. I will introduce our moderator shortly, who will formally introduce our two accomplished panelists, who are Josh Malone, a fellow at U.S. Inventor and the inventor of Bunch of Balloons, and Calvin Flowers, the director at the Chicago Inventors Organization and the inventor of Tel-Lock. However, first I have a few housekeeping items. Today's webinar is being recorded, and the link to the recording will be made available on the Illinois IP Alliance's website in the next few days. Number two, please consider using the grid view of WebEx to best view all our speakers. That's the one where you have the Brady Bunch-like view. It should be in the upper right corner of your viewing screen. That's where you can choose that option. The program will run approximately 1 hour until 1 o'clock, with the last 5 to 10 minutes being reserved for your questions for our speakers. You can send us questions online using the Q&A box on the bottom of your screen, and we'll do our best to answer your questions during the webinar. And finally, if you're experiencing technical difficulties, please use the Q&A box to alert us. Now, turning to our moderator for today's panel discussion, I'm pleased to formally introduce you to Professor James Conley. James, if you can wave your hand. James is on the faculty of the Kellogg Center for Research in Technology and Innovation at Northwestern University, where he teaches innovation and entrepreneurship. But not only does James teach, he's also practiced the subject matter he now teaches, in addition to serving as an expert on IP-related issues. He is an inventor and entrepreneur with a PhD in material science, and along with significant industry experience, he has also had the distinction of keeping company with one of the most prolific inventors of our time. James is a co-inventor on a number of patents with the late Jerome Lemelson of the Lemelson Foundation. In addition, the IP Alliance is proud to have James as one of our board members. James, we're honored to have you moderate today's panel discussion, and I now turn the program over to you.
Okay, thank you, Peter, for that very kind and thoughtful introduction. It is a privilege for me to lead and moderate this inaugural roundtable event for the Illinois Intellectual Property Alliance, addressing the question, as you've said, intellectual property supports innovation, but does it support innovators? As we begin this, I want to say just one thing about the mission of the Illinois Intellectual Property Alliance and why it was so formed. We really formed this alliance to serve as a connecting hub for local and regional organizations and to foster an effective innovation ecosystem and marketplace to facilitate the creation, protection, and enablement of intellectual property as an incentive system for our innovators. Hence, the ILIPA, which Peter mentioned evolved out of the Chicago Intellectual Property organization, is really a regional entity, and we're trying to pick up on all the voices that exist across Illinois and play into the larger hand of these intellectual property alliances that started in Georgia and are coming up across the nation. So in pursuit of this statewide ecosystem, I seek to realize with these kinds of events the vision that was actually expressed beautifully by Abraham Lincoln. How is it that we efficiently bring together the fuel of interest with the fire of genius? Turns out Illinois is full of creative professionals. The whole nation of the United States is. There's quite a legacy here. So that is our quest today, to bring together some of the creators in this ecosystem and to learn from those who have in the past and even more recently navigated through what is the patent portion of the intellectual property system to try and be successful entrepreneurs. So I am joined, as Peter said, by two celebrated inventors. First, Calvin Flowers, who is the inventor of the Tel-Lock, U.S. patent number 5774543. He is the president of the Chicago Inventors organization. We're going to hear about his story in just a bit. And then by Josh Malone, who Peter mentioned was the inventor of a bunch of balloons. This is patent number 9051066. As an academic and as an inventor, I find it helpful to know these patent numbers because you can look exactly where these creators were spending their time to push forward our collective enjoyment, and in this case, balloons. Both of these inventors have generated innovations. They have navigated the patent system. They've actually licensed their inventions. And they've run into all sorts of challenges associated with the legal system and the marketplace, which are not uncommon. So our quest today with these two really is to learn about what they've learned. And I will try and facilitate a discussion that cultivates a good foundation for what will hopefully be your questions about these collective experiences that we navigate through our conversation. Please put those forward to Peter in the chat, and if we have time at the end, we'll circle back to those. So we're going to start with Josh Malone, who is a serial inventor. He's going to tell us a little bit about his history and his journey with what has now become the commercially successful bunch of balloons. Josh, I hand it over to you. You're on mute, Josh.
I clicked it twice.
Okay.
Double click. Thanks, James. Thanks, Peter, for having me. I'm excited about the Illinois Intellectual Property Alliance and being able to be a contributor to that. So thanks, and I'll jump in and give the audience a bit of an overview of my most recent foray into the inventing world and how I ended up here as your panelist. Let's see if that'll come up for us. This is just a brief overview of some of my backgrounds with inventing. I was in high tech for a while at Texas Instruments, working on digital micromirror devices. Fascinating. The company grew, the division grew. I was feeling stifled. I went out on my own. In 2006, I invented a digital paper cutter. I licensed it and sold a few units. It was exciting. I was able to see my invention on the shelf with a first time success. I was very grateful for that. Then I crashed and burned. I had a major flop with a bracelet, make your own shaped bracelet invention. Lost a lot of money on that. And in the meantime, I had done a lot of consulting and just trying to pay the bills and get by and grind away as an inventor. And I was 7 years into the adventure, and it wasn't working out. I wasn't getting ahead, paying the bills. And I had one last opportunity, and that's when I came up with a bunch of balloons, which let me advance. There we go. I solved the problem. I figured out how to get these balloons to fill simultaneously and seal themselves. And I put it on Kickstarter, and it went crazy. It went viral. It was like it was the inventor's dream, and it was fantastic. Having it on Kickstarter was great. I was able to, on a tight budget, be able to get my product out there and demonstrate to the world, and the world loved it. And retailers wanted to order millions of units. I had an incredible opportunity here to move forward and build a business, and I elected to license. I definitely recommend licensing for inventors. I was able to meet up with a toy company called Zuru, who was very ambitious and very aggressive, and it was a good fit. They actually brought a lot to the table where they had distribution, they had manufacturing, and so we partnered, and they're the exclusive licensee of a bunch of balloons technology and patents, and we went to market. Backing up a step, in the middle of this process, it became very popular on Kickstarter and on viral social media, but it actually went mainstream. So I was on the Today Show and had a water balloon fight with Carson Daly in Times Square. That was quite an adventure. And so so all that's coming together. Our world's going crazy. This is just a dream times 1,000. And then Zuru, my partner, the toy company that I licensed with, we went into production. We built a factory to produce this product, and that was a really important key, was being able to scale this and being able to build a high quality, cost effective product. And that was the main thing. That was one of the top things that Zuru brought to the table. At this time, especially, this was a great partnership, great relationship. We went to market, and we were on our way to market, I should say. And before we could get there, the knockoffs beat us to market, as a matter of fact. I mean, I was on Kickstarter, and we launched first, but turns out they actually were watching Kickstarter, and they surreptitiously ordered one of my first edition products, reverse engineered it, changed the color, and launched their own copy. And I was stunned. I wasn't surprised that my invention was copied. I was surprised at the pace and the scale. And also, this wasn't, a Chinese knockoff on eBay. This was a big American company, domestic company, and they were selling it on national TV. And the next step after that is to go into the retail, which they did.
Josh.
Next summer, yeah.
But that's why we call them the fast follower, because they're fast.
They're fast, and this is low tech, right? But the same thing's possible in high tech industry as well now. And I was in the middle of it. These guys actually have a reputation. This is their business model. There's been books written about this company, Tel-Lock. They started off with Sony Walkmans in the 80s. Soon thereafter, it was Thigh Master. Well, Suzanne Summers was selling Thigh Master. They were selling Thigh Shaper. And I found these people have been, this company's been in over 100 litigations over intellectual property and consumer fraud. I also found out they didn't lose. They had never lost to a private party in 3 decades. And so this was the gorilla of this industry, and we were facing them. So at this point, we're talking about intellectual property, right? So that was the key. I thought, I've got a patent, or the patent issued, and I found out that these large corporations just don't care if you have a patent. So that meant nothing to Tel-Lock. They're like, what are you going to do with your patent? And so what we did is we went to court, ended up filing a lawsuit, seeking injunctive relief, and that was the number one area for us. A lot of patent cases now aren't, they're more about settlements and licensing. Ours was about get them out of our market. This is my exclusive right. I worked hard for this. We've invested in it. We got to get them out of our space. And so we went to court in Texas, my home district, but then it sprawled. We ended up in New Jersey. We ended up at the patent office, in the Patent Trial Appeal Board, which I'll talk about in just a minute, and in the appeals court. This thing just ballooned. You hear about the patent wars. Apple versus Samsung had a long battle over the iPhone and the Samsung version of that. This is the same system that entrepreneurs have to go through, and it's unbelievably complicated and expensive and lengthy. Here's the thing, though. They at this point they have to come up with a defense because otherwise the court's going to make them stop. And so usually you would think, if you're accused of infringement, your defense would be, we use a different technology. We developed our in-house. We designed around it. That's normally how it works. Well, that didn't work here because we caught them red-handed copying. So Plan B, or maybe the parallel option, is to say the patent's invalid and the patent office made a mistake, so we're not guilty. And so that was the argument they raised. They paid a hired expert to say that no one knows when a balloon is substantially filled with water, and so my patent's invalid for vagueness. And then another popular argument in these proceedings is obviousness. Well, if you just combine, an old plumbing device with a garden sprinkler with a gastrointestinal dietary balloon, you put those together, and that's obvious, and that's all Josh did. These arguments, fortunately, they didn't prevail, and we won an injunction. But at the same time, they were able to go back to the patent office, the Patent Trial and Appeal Board. So in 2011, the American Invents Act created a division inside the patent office, and their job is to review and usually cancel patents. So they've now reviewed almost 3,000 patents since the AIA went into effect, and they've invalidated 84% of them. And
Josh?
it's obviousness.
So this is what we call a second bite at the apple. First, you defeat them in court, and they get to try to take out your patent again?
Right. So that's what we have now. We have second, and actually sometimes third, fourth, fifth, up to 26 bites at the apple, where if you want to use someone else's technology and you don't want to pay them for it, you go to the patent office and you pay a fee, and you say, I think they made a mistake. And usually this tribunal of administrative judges will agree with you and yank back your patent. So I have the patent office supposed to be protecting me. A few months later, they're coming around and ripping up all my work. And they actually did invalidate my patent on the same grounds where I won in a regular court, eventually won in front of a jury. The PTAB, the Patent Trial and Appeal Board, determined that my patent was obvious and I didn't deserve it, and they're not guilty. So that's what we went through. There came a point where the system was just absolutely absurd. It was like a coffee-esque is the term I use, because you got one branch of the government that's enforcing the patent, and the other branch is, in one instance granting it, and another instance taking it back, and the whole thing, and they're conflicting. And so I ended up, the legal system wasn't working. I ended up, if I can get hold of my screen, I ended up going to Washington and protesting, because this is a First Amendment petition to the government. Like, what are you guys doing? And so we went through this process, ended up joining up with U.S. Inventor and several other inventors and trying to draw attention to the plight of the entrepreneur, the small entity that's drawn into this system that has evolved to serve multi-billion-dollar and now trillion-dollar corporations. And what I found is I didn't fit very well. And so I found my way, and I've met lots of other inventors, including Calvin, who's going to talk here in a minute. And we're finding our way to basically restabilize and restore some sensibility to the system so that entrepreneurs, again, can enjoy that fuel of interest that fuels the fire of genius. So that's we can talk more. I'm sure, James, you got more questions, but that's the basic background.
So that's the backstory. Thank you, Josh, for that. I'm hearing a little feedback, so we may have to mute ourselves. I know that you eventually sorted things out and settled with Telebrands, the company that kept on challenging you on all legal fronts. But this is relatively a new development, the ability to do it. When I was inventing, there was no patent trial and appeals board. The defendant only had so many bites at the apple, but now it just seems to be an infinite challenge and a tough spot for the Josh Malones of the world. Now, Calvin is coming at this from a little bit different kind of experience. Calvin, I know that you invented this very interesting thing called the Tel-Lock, which was important during the period when we all had landlines. But from that interesting invention and your commercialization experience, you've realized that you need to do a whole lot more from the point of view of informing inventors in the ecosystem. So if you wouldn't mind, just spend a few minutes telling us about your particular experience and how it informed the creation of the Chicago Inventors organization.
Okay, well, good morning, good afternoon, first of all, and I appreciate you guys allowing me to be on this prestigious panel. I'm Calvin Flowers, and I am the president of the Chicago Inventors organization, and I will share a little information on how that got started, the organization, because when it was first proposed to me to start this nonprofit, I thought everybody was crazy. But anyway, I'll tell you about this story toward the end. But I am an inventor, and I invented a product. It was called Security Jack, actually. And basically what the Security Jack is a 3-in-1 telephone line locking device. As you mentioned earlier, that when I invented this was back in the early 90s. And up until that time, the primary form of communication as far as telephone go was done by landline. So I invented a way to curtail telephone abuse at the time. And the reason that I came up with this is I was raised in a pretty big family. It was my mom and dad had 7 kids, and we only had one telephone line. And so we had to compete for who got to use the telephone first of all. And the other thing would be at the end of the month, when my mom would get the telephone bill, it would be humongous. And when she turned around and looked to all the kids and said, who was on the phone? Everybody would shake their head and say, it wasn't me, it wasn't me, it wasn't me. And so as a consequence, when my mom planned to buy a new dress, at the end of the month, she had to use that money to pay for a telephone bill. So I came up with this way, and like, keep in mind, this is back in the 80s and early 90s, and the phones were hardwired into the phone jack, and so when the touch tone phone came out, you were able to remove, they had detachable cords. You could take the cords out and replace it with other phones. So, the reason that I'm bringing that up is because when the phones were hardwired into the jacks, there used to be a lock that was called a rotary telephone. You guys are old enough to remember the rotary phone, right? Well, there used to be a lock out there where they would had a little silver lock that they would put on the phone to prevent the dial from turning. But when that rotary phone went out, then came in the touch tone telephone. So you didn't have the advantage of using that rotary phone. So that rotary phone lock. So I came up with a way to lock the touch tone telephone by putting a lock in the jack. And it turned out that I didn't know what I was doing. So I went to a college called Olive Harvey College. That's when I met the vice president of the Chicago Inventors organization, Dennis Daniels. He was helping me do some market research, and at that point I determined that there were more uses than just the telephone, you making phone calls on the phone, because at that time the internet was getting pretty popular. Y'all remember AOL? Yeah, darn, you had to wait to get in. And they were also using the landline to actually fax documents. So this became a 3-in-1 product. And once I got it to that point, I was able to sell it nationwide in Walgreens. That's after going through all the manufacturing processes and the prototypings and all that sort of thing. So I sold it nationwide in Walgreens, which turns out to be, now you guys got to keep in mind, I was just an inventor, and I had just really learned about the invention process. So when Walgreens said, come on, we'll take you nationwide, I had no clue on how to do business with Walgreens. You know, they started talking about logistics, sending product to the distribution centers. They started talking about EDI, electronic data interchange, and all these different processes that I had no clue on how to do. So I was fortunate enough to learn a lot of that at Olive Harvey College. I wasn't a student there. I was just taking one of the business plan writing classes. So once I got in there and they start explaining to me what the processes and the type of infrastructure that I needed to build, I was able to set up a corporation where I could take on investors. And I took on investors. I raised a ton of money. I messed up a ton of money, but somehow I figured it out. You know, unlike most of the inventors that come to me to the Chicago Inventors Organization, they have no clue. They got a great idea, have no clue. So, so I messed up all this money, but I figured it out. And then I was able to find a manufacturer that would produce the product, where I was selling it nationwide in Walgreens. But before I tell you what happened once I got in Walgreens, I want to tell you a little bit about how I was able to get inventory. Because I remember I had negative, well, I didn't tell you I had negative money, but I had negative money. I had no money. And so when I found my manufacturer, which is located in Glenview, Illinois, they gave me a deal where they called it a blanket order, where they would give me for me to get the price down to where I needed to be able to make a profit. I had to take 10,000 pieces, and I had no customer. And this blanket order required that I take 1,000 units every month, regardless, to get that price. So in my little office at Olive Harvey College, and then, yeah, by the way, they end up giving me a office space in there and an incubator program that they open. And so every month I was getting 1,000 units that were being put into my little tiny office. And then eventually Walgreens came through, so I was able to start selling the product, which is a whole story in itself. But I want to get to the point where I was selling nationwide in Walgreens, and then a little company by the name of General Electric, or at least a subsidiary of General Electric, they saw the product on the shelf, and they infringed on it. And at the time, I had a really big investor out of coming out of Missouri that was planning on putting in some significant dollars into the company. But just as we agreed to close the deal, I got a call from them saying, "Well, what are you going to do about this product called Lockjack?" Which is, I don't know if you guys can see this, but it's another version of my invention. And they told me all deals are off until I resolve that. So I lost that investment, and so we ended up. First, we sent out the cease and desist letters and all those things, but it didn't stop there. So we felt like our only recourse was to take them to court. And when I talked to the patent attorney, the litigation attorney, when he told me how much it's going to cost, I almost fell out. Well, you can imagine how I felt when they started talking about upwards of $1 million. So I left out of that attorney's office, and I found one eventually that took my case on a contingency basis. And what I mean by that is sort of like the way the car, when you're in a car accident, a lawyer will take your case, and they'll take a third and give you 2/3. So we ended up taking them to court, and that experience, it still gives me chills now because I was deposed for 2 days. You know, these guys coming in there with those $500 haircuts and you know, the Armani suits on it, and that alone was intimidating all by itself. And so they deposed me for 2 days. They tried to invalidate my patent. They went way back to something they found in 1920. And it just turned out that my patent, the technology in my patent was so basic that anything that you did was gonna infringe on the patent. Because I think maybe about 8, 9, 10 claims or something. It was really, really basic. And so they eventually settled out of court. We got a really, really healthy settlement out the deal.
So Calvin, let me ask a question. I'm sure that experience that you just related, especially the bit about the fire of interest not making it to the fuel of interest at the 11th hour.
Yeah.
How does that inform the operations of the Chicago Inventors Organization and actually help all of the people that we see on your website learn more quickly than perhaps you did in the School of Hard Knocks?
Right. And you know, Professor Conley, I think that's what my calling has been in the past year, because I'm still inventing products, but I'm so busy that I don't get the chance to pursue them. But when Security Jack hit the market and Walgreens, and then as infringement happened, I started to get a lot of press, especially when I got into Walgreens. And I started getting all these phone calls from all over the place. And I thought they were calling for my invention, that they want to buy it, they want to invest, or, you know, something to that effect. But they were calling because they were inventors too. And it was, you know, and a lot of people helped me along the way, so I felt obligated, or I won't say obligated. I felt like I had to play that forward. And so I would have them come into my office during business hours, and I would talk with them one-on-one. But then it started to get so the number of people got so big, it just swelled. And so I used what I ended up saying. So instead of talking to you guys one-on-one, I want to talk to you in a group. We used the auditorium at Olive Harvey College, and I had, I can't remember right now, but it had to be upwards of 25, 30 inventors that were in the room. And I shared my experience with them, and I told them that I would help them whenever I could. But before the end of the meeting, everybody was saying, why don't we start an Inventors Organization? And I was saying, you know, y'all start an Inventors Organization. I got a business to run, but I will help y'all as much as I can help you. And the phone wouldn't stop ringing for the help. So eventually my mentor told me, he said, Calvin, you're going to be that much involved in that organization, you may as well become, you may as well be a part of it. And interestingly enough, when they came up with the name, they wanted to name the Chicago First Black Inventors Organization, which was pretty interesting in itself. So we ended up setting up a 501c3. We got a lot of pro bono help from the Law Project, which they gave us some great attorneys that help us set up the legal processes and all the things that we needed. So that's basically how the organization got started.
Thank you, Calvin. And I think that's great how you're actually taking your own experience at the local level with our Illinois inventors, trying to help them navigate this minefield. But on the national level, here I return to Josh. We need to do some things to level the playing field, Josh. And I know you're part of U.S. Inventors, in charge of policy there and all the rest. Could you share with us how you're trying to improve the system so that Calvin's inventors don't have to navigate the minefield that you did, quite frankly?
Well, the first thing is we're showing up. for a long time, it made sense, right? I mean, patents are quintessentially American. America loves inventors. Got nothing to worry about was kind of the thought. In fact, up until I launched my product on Kickstarter, I had no idea that there was politics involved in the patent system. And so what we've done, and so there was a fledgling organization at that time called U.S. Inventor, and some inventors had been raising awareness about problems going, with the American Invents Act. There were some concerns with that, and the PTAB was what we consider a Trojan horse in the American Invents Act. It really wasn't. Everyone thought, well, yeah, if there's a mistakenly issued patent, then what's the problem with having that reviewed in a faster, cheaper, expert proceeding? And so no one really suspected that it was a scheme to eliminate competition from entrepreneurs. And so we weren't watching, but now we're here. I've actually relocated temporarily, I will say, and I have to qualify that. My wife will correct me if I don't. We're here temporarily to work with Congress and to work with the Patent Office on having the inventors' views represented. So, until recently, the debate's been multi-billion-dollar corporations on one side and trillion-dollar corporations on the other, and their interests are not at all aligned with that of an entrepreneur startup. So showing up, joining U.S. Inventor, usinventor.org, it's now a grassroots organization. We have inventors in all 50 states, and what we're doing is educating, and then we're mobilizing. So, we don't have huge lobbying budgets and K Street lobbyists that are representing our interests in Washington, D.C., but we do have local inventors, credible inventors, business owners, patent holders, applicants that are understanding these issues, and they're able to meet and speak with their representatives. We do a lot of other work as well. We're doing pro bono work, helping inventors who get, realize that they're in it over their heads when they go try to enforce their patents. We're working very actively right now, even with regulatory matters at the Patent Office. So this entire, the Patent Office is a $3.6 billion operation. It's got 8,000 examiners and 250 administrative judges and lots of other procedures and personnel, and we're actually participating in it's kind of classic American, we the people. And so we're showing up, we're learning, we're sharing information, and we're here to represent inventors and entrepreneurs. But it's a two-way thing. We've got to get everyone needs to be aware and engaged, because you can't just take patent rights for granted anymore. James, I think you're muted, buddy.
Thank you, Josh. As someone who sat 2 terms on the Public Advisory Committee of the United States Patent and Trademark Office, I hear you about that 10,000-person bureaucracy. They're well intended, but when Congress makes the rules specifically about the AIA that shift the balance of power to those that have the resources to fight legally, it's a tough battle. And I'm very grateful that there's the likes of you and U.S. Inventor in Washington. And we in the Illinois Intellectual Property Alliance want to enable Calvin and his Chicago Inventors organization with the knowledge that you are generating about how to actually show up and be participative as we, the inventors in this system, and change it for the better. So Calvin, tell us just a little bit more about the programs that you have there at the Chicago Inventors organization that try to bring along all of those fantastic inventors I see on your website.
Well, first of all, we have over 350 members. And basically our whole mission is to help underserved inventors navigate the invention process. To date, we have over, on our website, we got 90 members that we have patents, but since that time, it's past that now. I think we are closer to 100. Most of those inventors, we help them get those patents. We get a lot of assistance from the Patent Hub, which is a pro bono patent program. And now, one of the concerns that I'm hearing a lot now is they're starting to hear horror stories about PTAB. And a lot of them are saying, how can I, why should I be getting a patent? Or if I get a patent, what's going to happen? And so basically, we've had a couple of attorneys talk to them, and they kind of explained to them that a lot of this, the challenges that's happening now came after the American Invents Act, and that when they're engaging their patent attorneys, they have to be asking their patent attorney to draft that patent with the PTAB horror story, so to speak. Keep that in mind as they draft in the patent. So so that's one of the things that we're kind of advising them. But right now we're doing 3D printing. We have 4 3D printers in the office, so we're helping them with their prototyping. We're doing entrepreneurial classes every Tuesday night where we talk about pricing. You talk about marketing, branding your product.
You talk about dealing with Walgreens.
Yeah, dealing with Walgreens when you get there. Yeah. So, and how to build a team. You can't do this by yourself. And then also the importance of learning how to do Zoom. A lot of inventors are terrified of the technology, so we have to kind of educate them and bring their anxiety down. So, and all our whole mission is to help them navigate the process.
And I think that's a terrific thing that you're doing, Calvin, especially in light of some of the reports that have just come out of the USPTO over the last couple of years about underrepresentation. Right, the system in and of itself has historical representation going all the way back to Elijah McCoy, who developed the oil cup that enabled the spread of the railroads across the United States. So there's a great legacy there. So now I'd like to ask Josh another question. Josh, as you see young inventors come to you with ideas, golly, we don't have a bunch of balloons, but we've got a bunch of whatever is the next greatest thing. What do you tell them about the patent system and how to navigate it? We hear Calvin is sort of putting out the warning about the horror stories and work with your attorney to modify and anticipate the PTAB. How about you? What do you tell them?
In the spirit of the debate season, can I deflect and answer a different question first?
Josh, this is America. Onward.
No, I did want to tag off of what Calvin said and how the theme of the Illinois IP Alliance is, we're working nationally and we're up to date on what's going on. We reach out to Calvin. The Chicago representative in Congress, Danny Davis, comes to his meeting, learns more about what's going on, and he's the lead sponsor on the Inventor Rights Act. And it's a bipartisan bill. We've got Danny Davis, who's a Democrat. We've got Paul Gosar, a Republican. And so Arizona and Chicago are 2 of our most active and educated groups of inventors. And that right there shows me that it's very much a local issue. And that's our, the work that they did in opening those doors and the relationships they have with their representatives. So we actually have model legislation, not just model legislation has been introduced as a result of these efforts and the partnerships that we have. So I think the Illinois IP Alliance is the next. We're taking our game to the next level. But what advice do we give people? What Calvin said is right. There's some things you can do in the application when you're aware of how your patent is going to be attacked and challenged. At the same time, I found that you can follow the law perfectly. And you can cite 200, 300 prior art references. You can have your patent go through a re-examination. You can do everything perfectly, and PTAB will still invalidate it, saying it was obvious in hindsight analysis. And so, yes, there's things you can do. You're going to be an inventor. So if you insist on patenting, that means one day your invention is going to be published for the world to see. And once it's out there, you can't get it back. And we used to have a bargain where once your patent was published, you would enjoy the exclusive rights to it and have a fairly reasonable expectation that no one else will use it without your permission. So today, you have to keep in mind that that is not a certainty. Your patent can be reviewed at any point, any number of times, any number of ways, by any number of parties. And so with that awareness, I advise inventors, entrepreneurs, build your business assuming that someone's going to copy and steal your invention. That doesn't mean you quit and give up. You plan for that. And so you invest your capital accordingly. You become a serial inventor, and you have lots of improvements on products, incremental improvements, instead of betting the business on one home run. You do resort to trade secrets. In many ways, you can lock up your technology, and in a lot of cases with the trade secret. And then the other key is, I just have to emphasize, is we need to fix our patent system. So spend a little bit of time, and you don't have to spend any money. Just spend a little bit of time educating yourself and showing up for these meetings with your representatives, and give us. And maybe you can enjoy a patent system if we're successful and continue to grow in the next few years. But at least your kids and your grandkids can have a patent system where they can become an entrepreneur too. And so that's what I mean. It's be strategic, be educated, and I can't stop you from inventing. We tell horror stories, but I'm not going to dissuade a single inventor to not pursue his dream and invent, or her dream and invent. But I can help you do it wisely and not haphazard.
Thank you, Josh. As the faculty member here who's supposed to know the history of this, humanity has not come up with a better system for motivating the Joshes and the Calvins to actually solve the problem and disclose it than the patent system. It is the grand bargain that you reference, and it actually exists to try and discourage you to use trade secrets. Secrets were the tool of what we call the Dark Ages, 400 to about 1400, almost 800 years there, where all the knowledge in the world was kept in monasteries. If you've ever seen a picture of Mont Saint-Michel off the coast of Normandy, that's where all the knowledge was. Everyone else, no knowledge. Patent system comes along, the Venetians, the modern one, and knowledge diffuses. So another question for Calvin, right? Because he's really here in Illinois working on the ground, trying to motivate the action of all of these innovators, inventors, right? And traditionally underrepresented. What Josh said was critical, Calvin. How did you get Honorable Alderman Danny Davis interested in your activities to support this bill that he mentioned?
Well, actually, I was already working with Congressman Davis. Congressman Davis, he got a pretty large district. If you ever look at,
and he's a pretty powerful politician.
Absolutely. And we were doing some collaboration with him, with the University of Illinois Chicago, with Malcolm X College, where we wanted to get inventors that had shelf-ready products. We wanted to get them in front of the actual buyers at those institutions. And while I was working with them, Josh and Randy both gave me a call, and they're the one that first made me aware of PTAB. And so, unbeknownst to Josh, I did have a conversation with the congressman, and they were trying to set up Josh and Randy was trying to set up a meeting. But one of the challenges that we have as a nonprofit is that we're not supposed to be getting involved in politics. So it was more of Josh pushing it. I was behind the scenes saying, "Hey, Congressman Davis, some of these inventions are having some issues or some challenges, and that maybe you probably should listen to these guys." And I don't know exactly how they were able to put it all together, but at one of those meetings that we had at I think it was Rush Medical, where we were doing some presentations, and Congressman Davis announced that he was partnering with the congressman in Arizona, and I was saying, yay, so that's pretty much how that came about. Josh did most of the hard work on that.
Well, I'm not concerned who did the hard work. Getting those two together really was a wonderful thing, and both of you contributed, I'm sure. In fact, as I reflect on this quote, which framed really the purpose of this roundtable, the fuel of interest to the fire of genius. It isn't just the fuel of interest of the financial capital. It's the fuel of interest of our politicians as well.
Yes.
We need to get them engaged in this system that can lift all boats. And that's the hope that I see in the work that you're doing, Calvin, with what is traditionally the underrepresented community, and Josh, with you on the national level in Washington. So I just want to encourage our participants. We have a few more minutes left. We have questions that you can enter into the Q&A on the lower right-hand side of your screens if you want to surface some. But let me just ask another question of Calvin, really. When you're looking at options for your, what you say, shelf-ready products, do you also think about other ways to monetize simply because of all of that headwind that you're going to encounter in the patent system that Josh has given voice to? Do you think of other ways that might avoid the patent system?
Well, I don't know how well this will work, but in addition to the patents, I encourage inventors to come up with their own trademarks to go along with it to help brand that product. And that's well, I guess that's basically. And then the trade, of course, the trade secret. But I'm always pushing trademark your name, trademark your logo, build your brand, and maybe hopefully that will give you some leverage as far as to protecting your patent. But one of the things that I think about a lot is that I was very fortunate that my litigation happened before the American Invents Act. So you were able to, so we went directly straight to federal court. And I wanted to ask Josh a question if I can.
Please do, Calvin.
If the PTAB invalidates your patent, what's the other recourse after that? I know it's going to cost a lot of money, but what is the recourse once they do that? But before you answer, we just had our 10th annual Inventors Conference this past weekend, and one of the attorneys brought something to my attention that I wasn't aware of. His name was Xavier. I forget his last name. Don't kill me, Xavier. But he was saying that if your patent is rejected by examiner or rejected by the patent office, you can appeal to the PTAB, and then they can fight your case. And I thought that was like, it was like in reverse. But he was saying that if the examiner rejects your patent, you can appeal to the PTAB, and they will fight your case for you. So if you're going to speak to both of those, Josh, I appreciate it.
Yeah. So it's the Patent Trial and Appeal Board. And so the appeals process has been around for ages. And so if your patent is denied in the first instance, you can appeal to this same board. But in 2011, they added the trials part. So now it used to be Board of Appeals. Now it's the Patent Trial and Appeal Board. And so they're your friend if you're appealing, or they could be your friend. But if you're in a trial, that means that they're looking to invalidate your patent. And you ask a really good question: what happens next? Right now, there's a lot of confusion and disarray. I mean, we have cases where a jury has found in favor of the inventor, and the PTAB has invalidated the patents subsequent to that. And sometimes you can appeal it. Ultimately, I have an inventor now that we're working with out of Minnesota. He's been at the PTAB for the last 8 years. So this process, I tell him the bad news is these cases never end. But the good news is these cases never end. And as long as you can fund it, the attorneys love it, right? I mean, I don't know how many attorneys in the audience, but basically, if you can continue to fund it, usually there's another avenue. So in this Minnesota inventor's case, he was at the end of the line, and then the Supreme Court decided last week that maybe these patent judges are illegal because they violate the appointments clause. And so that gave him a second life. And now we're picking up his case, and we're going to ask the judge to hear his case because the patent office is never going to sort it out. And so that's where we come in. There's strategies and tactics, but obviously all of them, you can't get rid of the uncertainty or the expense. If you manage those, then there's usually a way.
Well, Calvin, you were going to say something?
Oh, no. I was just saying, wow, it's mind-boggling.
Yes, this is an ever-evolving system. The patent system that all three of us have navigated. I think I actually litigated before you did, Calvin. And every time they would go to what was something called a re-examination, which was something that was independent of the appeals board, I would add claims. Hundreds of claims. And so I loved it when they re-examined my patents, right? But that is a very difficult procedure now, and that advantage has been mitigated. But what I loved about this particular roundtable as we get to the end here is that we could hear the ideas that are coming out of Washington at the national level and the experiences that Josh is having. We could hear those cross-pollinating with Calvin and his group that is really trying to advance the interests of his inventors, those that are here in Illinois that would like to thrive, that would like to use this system, even though the system is imperfect. But it's very much dependent on we, the people, as Josh has expressed. We have to be able to see and participate in the conversation with the Danny Davises and anyone else who represents us in Washington. So I'll just let you guys close with a thought, if you have it, about what you're going to be doing going forward, starting with you, Josh.
Yeah. So, a lot of people ask me what's next or what are you inventing, and it's a luxury. Being able to invent is a luxury. So the question is how much time and resources do you have? How much fuel of interest do you have to work with? Well, having come through the Telebrand saga, I'm in a position where I'd love to go back to inventing and solve some really important problems that society still faces. But right now, that I've been given this platform and this opportunity, if I can make the system work a little bit better, we could have tens of thousands or even hundreds of thousands of brilliant, creative geniuses really empowered to go solve these problems rather than just my little brain. So I'm working on getting some stability and some predictability back, and getting us back to that point where if you're an inventor and you've got a legitimate breakthrough disruptive idea, you can get funded, you can follow the laws and the rules, and you can rely on your patents, you can build a business on it, you can partner license it. If we can advance the field, advance down the field a little bit further, then we'll empower a whole lot more people to get to work, and we're doing it. We're starting to move. We're starting to move it. So there's a lot of inertia though. So I'm going to keep plugging away and organizing. Appreciate you giving me the platform and allowing people to hear more about what we're doing. And I posted my personal LinkedIn account. I posted the U.S. Inventor website in the chat. So love to.
Thank you, Josh. And Calvin, what are you all doing going forward?
Well, a couple of things. First of all, I'm going to be directing my members to the Illinois Intellectual Property Alliance so we can help fight this fight, and also refer them over to Josh's organization as well. And the other thing is that we're trying to make it easy for inventors to get their products to market. We're going to be creating a e-commerce platform that's going to be added to our website, so that'll be coming real soon. And if I can just give my website right quick, is that okay?
That's fine, sure.
www.chicago-inventors.org. Phone number is 312-850-4710.
Thank you, Calvin. And thank you, Josh. I think today we, through this roundtable, have served the mission of the Illinois Intellectual Property Alliance to actually be a connecting hub for not just the Illinois inventors like the Chicago Inventors Group, but the national entity that is U.S. Inventors represented by Josh. It's been a privilege and a pleasure for me to chat with both of you and learn and share your experiences with our audience. Peter, if you have any concluding ideas, I have nothing more to say. I want to thank our audience for participating, and we'll look forward to subsequent roundtables.
James, Calvin, Josh, it was absolutely our pleasure to have you share your experiences and thoughtful questioning with us here today. Mickey, you're a wonderful co-chair and have been very key to the planning of today's event. And to our participants, thank you for joining us today. Please, please, please mark your calendars for November 10th when we host Damian Porcari, the Midwest Regional Director of the USPTO. And if you're not already a member, please consider joining the Illinois IP Alliance. Thank you, everyone.
Thank you, Peter. Thank you, Calvin.
Thank you.
Thank you, Josh. We'll follow up. Thank you, Mickey.
You guys stay safe.
Okay, we'll do that. Thank you, Calvin.
Okay.
Bye now.
Bye-bye.
Bye-bye.